Good afternoon, Madam President. I rise to speak in opposition to the bill before us. It's Senate Bill 658, which is entitled An Act Requiring Employers to Recall Certain Laid-Off Workers in Order of Seniority. I appreciate the accuracy of the title in this particular case. I think it's pretty clear what this bill does, and I do want to get into some of the more specific language because obviously we know that a bill is much more than a title. I just want to react to some of the comments made by the proponent of this bill before us. She mentioned that this bill is here because of the difficult circumstances we have endured. But I want to remind the chamber and anyone listening that while COVID-19 certainly has affected us all and in many significant ways, the things that this bill proposes to affect are really a result of policies enacted by the state government of Connecticut. So when we talk about the difficult circumstances we have endured, I would suggest that those difficult circumstances are a result of the governor's executive orders that, first off, classified some businesses as essential, while other businesses were classified as non-essential, including businesses that in some cases were right next to one another and certainly able to follow the same protocol and guidelines. Imagine a Target store, for instance, being open, allowing people to wear masks and social distance but still operate, and then a small business next door like a Susie's dress shop or something like that who gets, only a few employees every day, they would have to be closed. And that's a situation that I don't think was proper. I don't think it was constitutional. I don't think it was tenable. And, those are the types of things that have resulted in the quote-unquote difficult circumstances we have all endured. And I think that cannot be lost on anyone listening. And certainly some businesses were, in fact, hit harder than others. And I suppose I would not disagree that some of the businesses that are identified in this bill, which is food service, hotels, things like that, were in fact hit harder than others. But again, I would suggest that many of those were for the reasons that I just laid out and not solely because of the pandemic. I'm going to close my remarks today, but with some comments about just economics in response to the argument that this bill is designed to help people. And I'm just going to leave that right here. But I'm mentioning it because I want folks who are going to listen to the details about the proposal before us to really ask themselves who this is helping and whether this is truly the way we want our system of laws and government to operate. So, as I already mentioned, the title says an act requiring employers to recall certain laid-off workers in order of seniority. So an act requiring employers is the first part of that, which basically says this bill tells employers what to do. So anyone listening at home should understand very, very clearly that if you own a business, you don't own or manage your business anymore. This body owns and manages your business. This bill actually has a provision in it that says that if you bought a business from someone else, or even the assets of that business, that the state government's policy that they are putting in this bill before us will still take precedent over your own management or decision-making. This is what it's come to, ladies and gentlemen. Less and less individual liberty, less and less individual freedom, less ways for people to make their own way in life, less ways for each of us as free American citizens to pursue our happiness, which is the foundational and core principle of this great nation. Not only is this bill in a tremendous overreach because it basically says that this body is going to tell private business owners who are in business to make money, which I would also point out is exactly what they're in business for. The gentle lady, the chairman of the Labor Committee, who I have great respect for, she said that the purpose of this bill essentially is to prevent business owners from choosing to hire a lower wage worker to affect their bottom line. Well, in fact, that is exactly the way our system works. Our system is based on freedom, and business owners are in business to make a profit. And trying to paint that in a negative light is extremely dangerous in a free society, because all opportunity, all quote-unquote help that people receive is in the form of opportunity. And opportunity can only be created when there is production created by freedom for people to enter into different opportunities, businesses, and choose their own path. So I just wanted to point out that I take umbrage to the idea that somehow a business owner is doing something wrong or vile because they are trying to improve their bottom line. Because ultimately, that is what will benefit people of all races, backgrounds, colors, etc., as was mentioned. Real opportunity to succeed, and not the government stepping in to paint a picture of how things would be in their imaginary world. So this bill, by the way, is as was just amended, it was a strike-all amendment, which for those folks listening means that everything that was in the underlying bill is now gone and has been replaced with an entirely new document. And sure, many of the language items probably remain intact, but again, it's a brand new bill. And also, as is apparently a regular policy of the majority party, it happens on almost everything we do in here. Almost every time I get up to speak, I am getting up to speak on a bill that does not resemble what left the committee. And often I'm talking about something that I received only moments before. The language that I have before me, we received this morning, for example. It's not the way to do business. And it's also not the way that our system in this legislative body is supposed to work. The reason why we have a committee process is for the purpose of getting the public involved to provide comment, advice, and guidance to us on how to make the public policy for this state. The reason why we have a committee process is so that the members of those committees have the opportunity to debate, change, alter, amend the language before them so that they can send us a finished product for us to decide up or down whether it's going to become law. But sadly, that doesn't happen in this building very often, Madam President. Almost in every case, it's a strike-all amendment. So what the committee did has nothing to do with what's before us. And I mention it because it's a constant frustration for someone in the minority that I've got to react to this. You know, I drafted a bunch of amendments on the original language of this bill and then had to come back and change all those amendments after the fact because I'm given a new set of words and context that I've got to work around to find out exactly what those changes are. And it also misleads the public because the public was advised about some sort of bill proposal that doesn't exist anymore. They came to testify at a public hearing about some bill that doesn't even exist anymore, which may or may not have the same bill number, same title, but certainly not the same language. It's a frustration because just the other night, we had the bill on the domestic violence issue. And that, again, was a strike-all amendment added at the last minute, a bill that many people were very much in support of. In fact, it went through this chamber 35-1. I was the only one to vote no. And I voted no because there were sections added to the bill that were not there before. I was in support of the bill until those sections were added. And yet the public wanted to know from me why I was voting no against the bill, because all they understand is the title. It's a bad way to do business, Madam President, and it's dangerous to our system of laws and justice because I don't believe the average citizen, much less the people in this room, can track and follow every bit of language that comes through here that is becoming law. It is a monumental task. We have bills that are 70, 80, hundreds of pages long, and sometimes we have minutes to review them, if that. So this strike-all new bill that essentially tells businesses that the state of Connecticut will now manage their decision-making process about rehiring laid-off workers is also not just absurd policy, but it is very poorly written and it is very vague. And I would not even normally go through the trouble of asking a lot of questions on the bill because it's pretty straightforward. I like to get up and tell people what I think it says and whether it's good policy or not. But in this case, I've got to clarify a few things. So through you, Madam President, I have a couple of questions for the gentlelady, the chairwoman of the Labor Committee.
Senator Kushner. Please proceed, sir. Senator Kushner, prepare yourself. Senator Sampson.
Thank you, Madam President. So in, I believe what is Section 1, subsection 4, I'm starting on lines 17 through 22. This is the definition of employer. I believe that this bill creates its own definition of employer and somewhat narrowly tailors it. But I want to make certain whether or not this definition of employer includes the state of Connecticut or any municipal government. Through you, Madam President.
Senator Kushner.
Thank you, Madam President. Through you, I think the definition is clear. It's any person including a corporate officer or executive who directly or indirectly or through an agent or any other person, including through the services of a temporary service or staffing agency or similar entity, conducts an enterprise and employs or exercises control over the wages, hours, or working conditions of any employee.
Senator Sampson.
Thank you, Madam President. I take that to mean that we don't know whether it includes the state or municipal governments.
Senator Kushner.
Thank you, Madam President. I answered the question that was asked.
Senator Sampson.
Thank you, Madam President. Yeah, so here I am with a legitimate question about the bill that's before us because I don't believe the definition of employer is clear on whether this applies to state or municipal governments that are involved in any of these business operations. So I guess that will remain unanswered. It's either A, it does, and we'll find out if they are ever actually held to the same standard as private employers, or B, it does not apply to the state or municipalities, in which case, why is it okay to force private entities to do so and not the state or municipalities? Moving down to the definition of enterprise, which essentially is the definition that describes what industries are affected by this policy before us, and that is lines 29 through 32. It says hotel, lodging house, food service contractor, or building services enterprise with 15 or more employees. So I guess I would ask why, through you, Madam President, these particular industries were chosen, and particularly building service enterprises seems like an interesting addition. But I'd just like to understand exactly what was the purpose of choosing these several industries and not others. Through you, Madam President.
Senator Kushner.
Through you, Madam President. I believe this is a question that I've already answered, but I will repeat that these are certain sectors and industries that employ low-wage workers who we felt it was important to protect by this bill.
Senator Sampson.
Well, thank you, Madam President, and I appreciate that answer. I did not ask that question earlier. I don't know what was implied by that. I know you did bring that up in your beginning conversation. The thing is that many different industries employ low-wage workers, and am I to understand, and this is not a question I'm asking rhetorically, am I to understand that we are only drafting policy that affects low-wage workers? We are going to create a new set of rules and rights for them versus anyone else? And more specifically, we're only going to do it for low-wage workers that work in a hotel, lodging house, food service contractor, or building services enterprise. That doesn't seem like a good way to make public policy to me, Madam President. I believe that if we are going to apply a set of rules to employers and employees, that it ought to be uniform across the board. So moving on to section 45, which I think is line 45, which is subsection 11. And this is the most confusion I've had in a while reading this section about defining a laid-off employee. So a laid-off employee is someone who was employed for at least 6 months, according to this language, in the 12 months preceding March 10th of 2020. So they had to be employed between March of 19 and March of 2020 for at least 6 months. Okay, we got that. And their most recent separation from active service, or failure to be scheduled for customary seasonal work occurred after March 10th, but before 3 years from now. And this is presumably, as was described, because of the COVID pandemic. So I guess the first question I would ask, and I know that was brought up earlier on the amendment, but if this is in response to COVID and we are in the process of reopening Connecticut, and in fact, as far as I know, restaurants are fully open and hotels are fully open and building service enterprises are fully open, then why is it that this bill proposes to carry its effective date through December 31st, 2024? Through you, Madam President.
Senator Kushner.
Thank you, Madam President. Through you, this bill anticipates that we may not have reached a full recovery until that time.
Senator Sampson.
Thank you, Madam President. Forgive me, I love that answer. I love that answer because it implies that something in this document would have something to do with the recovery of the Connecticut state economy or these businesses. This particular bill, Madam President, is not going to result in any aid to the recovery or the jobs of those that are identified in the language before us. It also goes on to say that separation from active service was due to the lack of business or a reduction or furlough of the employer's workforce, the public health and civil preparedness emergencies, or, and this is an interesting bit of language, other economic non-disciplinary reasons. So, through you, Madam President, can the gentlelady please give me one example of an other economic non-disciplinary reason? Through you, Madam President.
Senator Kushner.
Through you, Madam President, I think the language is clear that we're talking about other economic reasons that were non-disciplinary.
Senator Sampson.
Well, thank you, Madam President. Well, I would suggest that other economic reason could be that this business has slowed down for something other than COVID-19, or it might mean that business is going through a difficult time because the owner invested in another project, or who knows? Am I to understand that is a broad definition that would include anything that is non-disciplinary that affects the economic condition of that business? Through you, Madam President.
Senator Kushner.
Through you, Madam President, this bill would affect any other economic reason that was non-disciplinary.
Senator Sampson.
Thank you, Madam President. I appreciate the gentlelady reading the language before me in the bill, but I'm asking these questions for legislative intent. I really want to understand how far that statement goes. Not to mention the fact that we have in our existing law standards for what it means to be laid off. You know, people quit jobs. People are fired from jobs. People are simply let go. And then, of course, sometimes they're laid off. Through you, Madam President, does this language that is before us apply to someone that quit their job? Through you, Madam President.
Senator Kushner.
Through you, Madam President, I don't believe this would apply to someone who voluntarily quit their job.
Senator Sampson.
Thank you, Madam President. Would this language apply to someone who was fired from their job?
Senator Kushner.
Through you, Madam President, I think it would depend on the circumstances that both in terms of whether someone quit or were fired, it would be important to know whether it had any relationship to a layoff. And so I don't think this bill intends to cover people who voluntarily quit or who are disciplined for cause, but I think that would be clearly, that would be up to the courts to determine if there were a question regarding this.
Senator Sampson.
Thank you, Madam President. Well, that's precisely why I'm asking, is because a court is going to rely on this language. This stuff we're putting right here, this print that I'm reading, is going to become the law if this passes. And they're going to be relying on this. So I think it's important that we get to the bottom of who it actually covers. Connecticut is an at-will employment state, which means that if an employer or the employee want to terminate their employment at any time they can, they don't need a reason. So I'm asking through you, Madam President, again, I think it's quite clear that somebody who is defined as a laid-off employee is not somebody who quit. And it certainly shouldn't be somebody who was fired. But what about someone who is simply terminated? And no reason was given because no reason is required. Through you, Madam President.
Senator Kushner.
Through you, Madam President, I think the bill is clear that any layoff, the person would have certain rights protected.
Senator Sampson.
Thank you, Madam President. I appreciate that. And forgive me that I keep asking the same question different ways, but I'm asking very specifically, what does it mean laid off? Does that apply to someone who was quit, fired, or terminated without cause? Through you, Madam President.
Senator Kushner.
Through you, Madam President, if a person was terminated for economic reasons other than disciplinary reasons, I think they would be covered by this bill.
Senator Sampson.
Thank you, Madam President. I'm going to take that to mean that this applies to any business that makes a choice to get rid of a single employee for any reason. That's what I'm going to interpret it to mean. I think that's terrible. I don't think that's what the bill intends, but I think that's the response I'm getting. Other economic non-disciplinary reason is beyond vague. And I would assume that you can't ever say that as an employer you got rid of an employee either by firing them or letting them go or even laying them off, any of those things, that the amount that you're paying them is not a factor. It obviously is. There could be many, many other much more weighty and important factors, but obviously that's a factor. So I think we are leaving a court no choice but to say that any reason is an economic reason. And Madam President, forgive me, I am not trying to give the chairman a difficult time here. I just would really like some clarification to say that we are not talking about people that voluntarily quit their job. If we had that on the legislative intent on the record right now, I would feel much better that this bill is written in a way that makes some kind of sense. Because the way I am reading it and the way I'm interpreting the responses that I'm getting, it is that it applies to everyone because everyone's separation from active service, as it's said in the bill, is going to have some sort of economic impact. I don't want to just keep asking the question because I'm going to get the same answer, but I am going to ask several other questions, and the chairman will have a chance to clarify a number of things. I would really like to know where that really stands, because to me that may be the most vague and difficult section in this entire bill. And we have a responsibility, Madam President, that when we write laws, one of the things that we must do is we must make them clear. Many challenges to existing law come out of the fact that the language is not clear. And we right now have established that this is completely unclear. It goes on to say in subsection 12 that the length of service includes periods of time when the employee was on leave or vacation. I think that's absurd, actually. If you had two employees and you were trying to determine their seniority and one of them was on leave for 6 months and the other one was not, but they had total service that was a day less than the one that was on leave, we're still going to count the person that was only there for a much shorter period of time. Going down to subsection B on line 65, it says not later than 5 days after a job position becomes available, the employer shall notify each of its laid-off employees. So following up on my previous line of questioning, Madam President, who exactly must the employer notify that a job position is available? Through you, Madam President.
Senator Kushner.
Thank you, Madam President. Through you, they must notify each of its laid-off employees.
Senator Sampson.
Would that mean, through you, Madam President, that they have to tell people that were let go without a reason?
Senator Kushner.
Thank you, Madam President. If they laid off any employees during the period of time this bill specifies, they would have to notify each of those employees.
Senator Sampson.
Thank you, Madam President. Would that mean that if I'm an employer and I said to someone, I'm letting you go, but I want to make it clear I'm not laying you off, that they do not have to notify that person through you, Madam President?
Senator Kushner.
Through you, Madam President, I think the language of the bill is clear, and I think it will not be difficult to interpret who is laid off.
Senator Sampson.
Respectfully, through you, Madam President, if the language of the bill was clear, I wouldn't be asking the question, and you would be giving me a definitive answer, and I'm afraid we're not getting that, either one of those things. But I will move on. Moving down, it discusses which employees are qualified. And it says on line 70, it starts, a laid-off employee is qualified for a position if the employee, number one, held the same or similar position at the enterprise at the time of the employee's most recent separation. I won't dare ask the question of what defines similar, because I think that is completely a subjective term, and I think it also creates another area of vagueness that can be exploited by someone who wants to use this law that we're creating for ill intent. Number two, or can be qualified for the position with the same training that would be provided to a new employee hired for such position. You heard me, ladies and gentlemen. That basically says that you are qualified for the new position if you were laid off, whatever that means, by the employer, and you could be trained to do the job. I'm wondering who that doesn't apply to. It doesn't sound like it applies to anyone. So it sounds to me like this bill opens the door for any person who had ever been employed, and it says that any person who could be trained to do the position counts as that person. Going down to line 84 and 85, it says an offer of employment to a laid-off employee pursuant to the section shall be at substantially the same employment site. Another completely subjective word. Who knows what subjectively or substantially means? Does that mean on the same street? Does that mean within 25 miles, as is mentioned somewhere else in the bill? Who knows? Lines 93 through 105 is the section about what happens if a quote-unquote laid-off employee declines the offer after the employer was required to notify them that the job has become available. And it says that they have 5 days in which to accept or decline the offer. But then it goes on to say, believe it or not, Madam President, it says that if the laid-off employee declines the offer, such employee shall still retain his or her right to accept a position and retain all other rights, et cetera, et cetera, et cetera. I find this shocking, that even if the person declines the job, that they still have their right to accept the position. It goes on to say in subsection E in the paragraph 106 through 113 that the employer, if they decline to rehire a laid-off employee on the grounds of lack of qualifications, they have to provide that laid-off employee a written notice explaining why. I'll just remind everyone that we are in an at-will employment state. You don't need to give anyone a reason for leaving your job as an employee or for suggesting that you are no longer in need of an employee's services in this state. And yet, this language makes a giant leap to say that once you've already gotten rid of an employee, which we've already established could mean quit, fired, let go, or terminated without cause, that you've got to offer them their job back simply because of the length of time that they worked is in excess of another one. And I didn't even get into the fact that it only is the length of time worked in that defined period between March of 19 and March of 2020. Has nothing to do with their service beyond that or since then. But now we've got to have that employer has got this additional burden on them that they have to explain themselves to the employee why they chose someone else. Line 119 through 121. The ownership of the the requirements of this section shall apply under any of the following circumstances, the preceding paragraph, and it includes this language that says the ownership of the employer changed after the laid off employee was laid off. So the person's laid off, someone comes along and buys the business. Guess what? The new owner of the business, who does not even know this person or their qualifications, now has to offer them a job. I started this debate, Madam President, by saying this body thinks that the business owner doesn't have any right to manage their own business. This goes so far to say that even if you buy someone else's business, you don't have a right to manage that business. The next several sections, Madam President, have to do simply with what the penalties are and what the remedies are. And I'll spare the every detail because it's several lengthy paragraphs, but suffice it to say that it's completely one-sided. It makes it quite clear that a laid-off employee with the vague definition that is aggrieved by a violation of any provision of this bill can bring a civil action. So they have the actual right to sue over this created by this legislation, despite the fact that we are in an at-will employment state. And it goes on to say that they are eligible not only for reasonable attorney's fees and costs, but also for treble damages and so on. Through you, Madam President, is the employer eligible for such damages if it turns out that the employee is the guilty party in such a transaction where possibly they did not indicate their previous length of service accurately to the new business owner? Just as an example, there are probably a dozen others.
Senator Kushner.
Through you, Madam President, the bill lays out that the court could find and award treble damages if they prove that the employer terminated the laid-off employee in violation of the provisions of subsection H of this section, and subsection H protects employees from retaliation from an employer for asserting their rights.
Senator Sampson.
Thank you, Madam President. Again, I don't believe my question was answered. I'll just save the suspense and say that the bill is completely one-sided. It does not offer the same benefit to the employer, only to the employee. One of the great tenets of our society is that we provide equal protection under our laws. This bill is an example of defying that mandate that I believe we are all under as a consequence of our oath of office. And it creates so many inequities, it's actually hard to describe. Because this bill not only creates the inequity I just mentioned between employer and employee, as far as their ability to have remedies for damages in the case of a dispute, but it also creates inequities in many, many other ways. And yes, I'm using the word inequity on purpose, because that's what I'm constantly being told that we are supposed to be fixing in 2021 is all the inequities of the world. And yet almost every policy that the majority puts before me is creating an inequity. This one says that certain businesses are subject to these specific rules and requirements, while other ones are not. That sounds like an inequity to me. Madam President, no matter which way you slice it, I think this is a horrible bill. I think this is a tremendous overreach. This is the type of policy that I can't even imagine is being debated to become law in our state. It shocks me to my core. I'm not kidding. I'm not standing here before you as a state senator saying that. I'm just a citizen in this state. And when I get up in the morning and I find out the type of laws that we're passing includes this type of thing, I shake my head in disbelief, Madam President. I cannot even believe, the gall is the word my mom would use, that this state Senate would think that they can pass a law to tell someone that they got to run their business this way. People who own their own businesses invariably have sacrificed tremendously to get to their position of being a business owner. And during this most recent period, it is those business owners that have sacrificed more than anyone. The idea that we need to create it with an artificial set of circumstances to help these employees is a very nice and noteworthy gesture, but it just doesn't meet with reality. The fact is that the employees of these places have been helped tremendously already. There have been billions of federal dollars expended to help them. There are programs after programs. People are paid more money in unemployment than they could get for working. And yet we are going to come up with more policy that is one-sided in and against the employer once again. I have several amendments, Madam President, that I'm going to offer. And then I will just make a very brief closing statement. I'll just preface the amendments by saying that none of these will make this bill worth voting for, but I would encourage my colleagues to vote for them anyway because they are necessary to make this bill clear, to make this bill workable, and to make it even somewhat recognizable as legitimate public policy, which it is not currently. So, Madam President, the clerk has Amendment 9224. I ask that it be called and that I be allowed to summarize it.
Mr. Clerk, would you please call LCO 9224?
LCO 9224, Senate Schedule B.
Senator Sampson.
Thank you, Madam President. This is a very simple amendment. It strikes subsection 11, which is the definition of laid-off employee, and it adds a letter D at the end that says that applies to those who did not reject on or after March 10, 2020, and before the effective date of the section, an offer of employment from the employer since such separation from active service or failure to be scheduled. I think it's a good amendment. It clarifies that someone who rejects an offer is not eligible and considered to be a laid-off employee. I urge adoption, and I'd like a roll call vote. Thank you.
Thank you. And the question is on adoption, and we will have a roll call vote on the amendment. Will you remark further on the amendment that is before the chamber? Senator Formica.
Thank you, Madam President. I rise in support of the amendment. The amendment does not disqualify anyone from being asked to come back to work. It simply puts the onus on the employee if they reject the offer to come back to work. And at some point, there has to be individual responsibility in this state. Thank you, Madam President.
Thank you. Will you remark further on the amendment before the chamber? Will you remark further on the amendment that is before the chamber? If not, a roll call vote has been requested. Mr. Clerk, if you could please call the roll.
Immediate roll call vote has been ordered in the Senate. This is Senate Bill 658, Senate Amendment B. Immediate roll call vote has been ordered in the Senate. This is Senate Bill 658, Senate Amendment B. Immediate roll call vote in the Senate on Senate Amendment B. Immediate roll call vote in the Senate.
Please announce the tally on the amendment.
Senate Bill voting yea 12, total voting nay 18, absent not voting 6.
The amendment fails. Will you remark further on the bill before the chamber? Senator Sampson.
And thank you, Madam President. I am disappointed that yet another amendment that would have sought to clarify what I think is bad policy, but if we're going to do it, we should do it properly. I'm afraid that failed on a party line vote for anyone watching at home, and I think I'll make a point of explaining that each time it happens. So I have another amendment, Madam President, which has to do with the basic underlying premise of this bill, which is that the idea that an employer should be able to make their own decision about which laid-off employees are returned to work should be up to them, and possibly based on like important things like that employee's productivity or how many skills they possess, their level of training, their performance, any of their past disciplinary action, or even their attendance history. All those things are ignored in this language, Madam President. The only thing that matters is that you worked and you are qualified. Qualified meaning that you could be trained to do the job. It's almost laughable. So the amendment that I'm going to propose tries to rectify that situation. It is LCO 9220. I ask once again that the clerk call this amendment and I be allowed to summarize.
Mr. Clerk, if you could please call LCO 9220.
LCO 9220, Senate Schedule C.
Senator Sampson.
Thank you, Madam President. This amendment adds a little bit of clarifying language to subsection B of section 1. The bill is only one section, but this is subsection B, which has to do with the terms when an employer offers a job position to a formerly laid off employee, whatever the definition of that may be. It says that in the amendment, the language is added that not only would it have to, an employer would have to take into consideration the items that I just mentioned, which is that the employee worked and could be trained to do the job. It adds the substantive and important parameters, and the language is where more than one employee is entitled to preference for a position, the employer shall consider each entitled employee's skill level, attendance, and disciplinary record and length of service with the employer before offering the position to any such employee. The fact that we would have to put that in a statute shocks me to my core. I don't like even putting it in a statute, Madam President, but it is far better than leaving it without this language. I move adoption and like a roll call vote.
Thank you, and we will have a roll call vote, and the question is on adoption. Senator Kushner, will you remark on the amendment before the chamber?
Thank you, Madam President. I would just like to comment that this bill is established to set objective criteria that will reset for the employees the conditions that they had prior to layoff, and I would urge my colleagues to vote no on the amendment.
Thank you. Will you remark further on the amendment? Will you remark further? If not, a roll call vote has been requested. I will open the machine. Mr. Clerk, please call the roll.
Immediate roll call vote has been ordered in the Senate. Immediate roll call vote has been ordered in the Senate. This is Senate Amendment C, Senate Bill 658. Immediate roll call vote has been ordered in the Senate on Senate Amendment C, Senate Bill 658. Immediate roll call vote in the Senate on Senate Amendment C. This is Senate Bill 658.
All the senators voted. Have all the senators voted? The machine will be locked. And Mr. Clerk, please announce the tally on the amendment.
Senate Bill 658, which is Senate Amendment C. Total number voting 31. Total voting yea 12. Total voting nay 19. Absent not voting 5.
The amendment fails. Will you remark further on the bill before the chamber? Senator Sampson.
Thank you, Madam President. Once again, another party line vote and another, what I think was a very simple question, which is, do we think that employers should include, when they are bringing back employees that are laid off, skill level, attendance, disciplinary record, length of service? The vote before us simply said that some people said yes and some people said no. And I'm happy to consider myself in the category of someone who believes that that is legitimate for an employer to consider those items when they bring someone back to work. I've got one more amendment, Madam President. This one is LCO 9226. And once again, I would genuinely appreciate the clerk calling this amendment and your permission to summarize it for the chamber.
Mr. Clerk, if you would kindly call LCO 9226.
LCO number 9226 626, Senate Amendment D.
Senator Sampson.
Thank you, Madam President. This is a very simple amendment that adds a new subsection at the end of the bill. It simply says that when you're dealing with an employer that is doing their best to accommodate this policy, which I don't know why they would, other than it being the law, and they attempt to rehire a laid-off employee, this would prevent them from becoming civilly liable, because there potential exists that by following the procedure that is laid out in the bill before us, they may in fact be violating other prohibitions or on discriminatory hiring or affirmative action policy, etc. And I would like very much to make sure that employers that follow what I consider to be this horrendous policy, but because they're following the law, they should not end up becoming civilly liable. And this is a very simple up or down vote. If you believe that an employer following this procedure as laid out because this body has decided that this should be the law, whether or not they should be open to liability for doing such, I would say they should not. So if you vote yes for the amendment, you are protecting those employers. If you are voting no, then you don't seem to care. Thank you, Madam President.
And thank you, Senator Sampson. Senator Kushner, will you remark on the amendment?
Thank you, Madam President, and I would just like to urge my colleagues to vote no on this amendment. I don't think it's necessary, and I would like a roll call vote.
Thank you. There will be a roll call vote. And Senator Sampson, do you move adoption?
Yes, ma'am. Forgive me that I forgot to move adoption. I move adoption on that amendment.
Thank you. And a roll call vote has been requested. Will you remark further on the amendment before the chamber? If not, a roll call vote has been requested, and I will open the voting machine. And Mr. Clerk, please call the roll.
Immediate roll call vote has been ordered in the Senate. This is Senate Bill 658, Senate Amendment D. This is Senate Amendment D on Senate Bill 658. Immediate roll call vote has been ordered in the Senate. This is Senate Bill 658, Senate Amendment D.
Mr. Clerk, please announce the tally.
Senate Bill 658, Senate Amendment D. Total number voting 33. Total voting yea 12. Total voting nay 21. Absent not voting 3.
The amendment fails. Will you remark further on the bill before the chamber? Senator Sampson.
Thank you, Madam President. So I'll just recollect, as I did on the previous amendment, this amendment also failed on another party line vote, with all Republicans trying to protect the civil liability of employers who are cooperating with the terms of this bill, which I would venture none of us will support, and all Democrats voting against an amendment that would protect the employer for liability just for following the bill that they have proposed and that is before us. There are very few things, Madam President, as I get older that I am certain of. But one thing I am certain of is that this is a bad policy. I will just come full circle and suggest that the only thing that's clear about it is that it is an indication that there are members of the Connecticut State Senate that believe that business owners do not have a right to manage their own businesses, and that this body has the ability, I won't say right, but the ability and the force capable of managing them for them via these, what I consider to be oppressive edicts. The other thing is that this bill is completely unclear. I did not get answers to a great many questions throughout the debate, which I wouldn't even consider a debate. That's the purpose of us being in this circle and discussing this legislation, by the way, Madam President, is that we're supposed to be exchanging ideas. We're supposed to be clarifying the language before us. We are supposed to be creating legislative intent so that people on the street and attorneys that might have to deal with this can make sense out of it in the future. And yet, we got none of that. We have the words on the paper, which I have made abundantly clear, are not abundantly clear. We still do not know truly whether state or municipalities are included in the definition of employer. We do not know why these industries were chosen as quote-unquote enterprises. We're also a little curious about the actual definition of hotel, lodging house, food service contractor, and so forth. Even though there's a definition in the bill, I don't think it is clear, like other places in our statute, that really define what a hotel means. Most importantly, we don't know what it means to be a laid-off employee. I received mixed information, and mostly just it is what the bill says, which is definitely not clear. There is a difference, especially in an at-will state, between quitting a job, being fired from a job, being let go, simply let go without a reason, and being laid off. I am hopeful, Madam President, that folks in the future will only look at this bill as if it applies to someone who is genuinely laid off. But I am concerned because I think this definition that is described in subsection 11 is beyond vague. The fact that this bill includes periods of leave or vacation as part of someone's service time is absurd. The idea that we are still worried about COVID all the way till December 31st, 2024 doesn't make any sense. The fact that this bill does not take into consideration anything that an employer might have gone through that's not related to COVID, whether they eliminated a line of business or stopped producing a product or relocated their service or whatever. None of that seems to matter. It also doesn't seem to matter that if someone was offered a job to return and they rejected it, they still have their right to accept a position. There are truly absurd things in this bill, including the fact that if you buy someone else's business or the assets to that business, you are now responsible for following this policy for something the previous owner did. If they laid off someone, you have to bring them back. You don't even know who they are. As was just pointed out via the second amendment that I offered, no consideration is made for the actual qualifications of an employee. That does not seem to matter to the new managers of Connecticut's businesses in these industries. The old managers, the actual business owners themselves, I'm quite certain care about the skill level, productivity, training, performance, attendance history, and past disciplinary action of their employees. But this bill says no, none of those things matter. I hope it's clear just how absurd this is. Would you know that that new employer, by the way, that has to hire that person back, they have to contact this person and ask them to come back at a job, even though the old business owner is not there? And how could they possibly give that person the reason why they were laid off if they didn't even work for them at the time? So let me just close, Madam President, by reminding people of what I said from the very beginning, which is that this is nothing more than this body taking a role in our society that it does not belong in. It is up to employers and employees to develop their business relationship based on the fact that they are free citizens in the free United States of America. And while our job is to protect people, to provide for public safety, to put necessary regulations in place, our job is not to mold society. Our job is not to dictate to someone who owns a restaurant how they're supposed to run their business. It's certainly not to tell them who they have to bring back to work after they've laid someone off without considering anything other than their length of service. It's an absurd bill, Madam President. I hope the world can see that. It's a very simple vote for us today. If you believe the government doesn't have the right to tell business owners to do this, you vote no. But if you believe the government should be micromanaging every mom and pop restaurant, hotel, food service, and so on in this state, and that they have the right to tell them who they can bring back and when, and not leave it up to the employer themselves, then I suppose you vote yes. But one message I want people to understand is this, contrary to what was stated from the outset, will help no one. No one will benefit from this. This will only be cited as another reason why businesses have left this state or ceased to operate. I saw a statistic the other day that said something like 600 restaurants have closed over the last year. Yes, partly as a result of COVID, but also, and more importantly, as a result to the government's response to COVID, which is the real problem that we are doubling down on here. If you really want to help people, especially, I heard mentioned people of color, low-income jobs, which I don't think those things mean the same thing, by the way, and I find that offensive. But if you really want to help people, what you do is you create an economically viable state for people to want to do business in. That's what you do. And the way you do that is by removing the reins of government regulation that is unnecessary and letting people run their businesses the way they choose. You create opportunity where people want to go to work because it's better for them to go to work than to collect unemployment. Everything this state has been doing for the last year and many, many years before that is wrong, counterproductive, and is only going to lead to more and more problems. I urge my colleagues to vote no and send a message, Madam President, that we are not going to keep micromanaging businesses and we do care about the future of this state's economy. Thank you.
Thank you. Will you remark further? Senator Kushner.
Thank you, Madam President, and I will be brief. I just want to say that in my experience here in this chamber, I've heard us debate many bills. I've heard us take responsibility for passing good laws. I think this is another one of those good laws. I know there are many employers that have needed our assistance, whether that's come from the state of Connecticut or whether it's come from federal government. I have applauded those efforts. But I also recognize that part of my responsibility is to make sure that we are also recognizing the needs of the working people of our state. And I believe this is a good bill that will help workers to reset, to regain employment, and that will help us to all recover from the pandemic. So I urge my colleagues to vote yes on this very important piece of legislation. It reflects well on our chamber and it reflects that we are paying attention to the needs of our communities. Thank you, Madam President.
Thank you, Senator Kushner. Will you remark further, Senator Formica?
Thank you very much, Madam President. I rise in opposition of this legislation, and I will very briefly